Okay, so what do you do when you get to court? Pretty much this is the routine that I'll have. We kind of talked about when the case would be called. You have to know what court you're in. But usually I'll come in. If the family's there, I'll speak to them, introduce myself. We've probably only spoken on the phone. Tell them to give me a couple minutes to do a few things, and then I'll circle back to them. I'm going to go into the court. I'm going to submit a notice of appearance and let them know that I'm the attorney on the case. Some courts will give me copies of the paperwork at this time, which I think is the correct procedure. Some courts will not give me paperwork. They will wait till the arraignment actually takes place, which I think is not the proper procedure, but we can't convince them to do anything different. It does make it a little difficult to talk to the client, and they want to know what exactly they're charged with, and you don't know the specifics yet until you do the actual arraignment. But it is what it is. We get the paperwork if we can. I'm going to speak with the prosecutor if I can. Sometimes they're in the courtroom, sometimes they're not if we haven't started yet. Find out if they're asking for bail. Find out maybe a little bit about the case so you can have a better understanding of what their opinion is. And then I'm going to go speak to my client. Again, different in every county. Some lockups, you have to speak to your client through the bars with 20 other people listening. Some lockups, you're able to, there are little booths off the regular cells that you could sit down and shut a door and nobody else hears your conversation, which is really how it should be. But I'm going to go in, I'm going to talk to my client. Possibly the first time we're meeting, I'm going to explain again who I am. Give them an idea of what they're charged with, give them an idea of what I think is going to happen, how court's going to work once we go out there, and just try to reassure them and give them some information. And try to learn a little bit from them if I can, because if I have to make a bail application, maybe I've spoken to the family, but I want to get the direct information from the client. Then I'm going to finally circle back around to the family. Usually we'll have some time now, and I'll be able to explain in detail what the client is charged with, what I think may happen if I know. But really, what all we're really concerned about at the arraignment is getting the client out of jail. That's the only thing we're really concerned about. We can't do anything else at the arraignment. We can't get the case dismissed. There's no point in arguing, why my client shouldn't have been arrested. It's all about making sure the client goes home, and then we can figure out next steps. Oh, and just to double back to being retained for a second, what I will usually do in these circumstances is I'll usually give a client a price for the arraignment, and then once I see exactly what they're charged with and I can assess the case a little bit better, then I'll give them a price for the actual case, and I'll explain that to them when we start.